take a second bite. We would like to argue both of them together. Secondly, we would like an allocation of time, because it is quite clear to us that in the absence of directions allocating time, we are going to have another long afternoon of long-winded speeches that do not address the specific issues. We are willing to say in advance that whatever time you give us, if you give 10 minutes each, we shall accept. If you give 15 minutes each, we will accept.
Professor Giffey, yes, my applications have been filed. How many applications?
The one you directed, my lord, in the morning.
Yes.
Yes. But it is in that application that has been filed by Jindo Matiba and company advocates. That is the application that seeks, on the one hand, that questions how this bench was appointed, and on the second hand, it requires the recusal of this bench.
So for avoidance of doubt, it is one application?
It is one application.
There are three applications.
But there is an earlier application for recusal. And that's why I'm saying we probably can hear both of them together.
Yes.
I'm sorry, my lord, but my lordships and my lady, I just wanted to remind the court of Article 159 of the Constitution. In exercising judicial authority, the courts and tribunals shall be guided by the following principles. And 159(2)b, justice shall not be delayed. So I'm requesting your lordships and my lady to kindly refer to that provisions and let us move forward. Thank you.
My lord, let it come on record that this is the first time in which, on a matter of extreme national importance, we've been given 1 hour to be able to do an application, serve it, and come back to court. We have tried to do the best that we could in terms of complying with those directions. Of course, one of the issues that we could not be able to do is that the written application could not be able to do full justice to the instructions that we've been given and to our case. And therefore, my lord, when Professor Gedhu Muigai stands senior counsel to say that we need to be gagged on the issue of time, we protest. We shall require sufficient time. This sufficient time is not forever. This sufficient time, at least for purposes of the three presenting the one of that applications, is 1 hour. It is the least that people deserve in an application of this nature. Secondary issue, my lord, is the issues of consolidations. Those issues of consolidation are as different as UDA can be from Jubilee. And the issue is, for purposes of the difference, the application under Article 165, and we did not hear you talk about the inclusions, because we've had to include. Their earlier complaint in the morning...
I'm sorry to say this.
I have...
Yes, I want to interject. If my learned friend is appealing against your orders, then there is the right forum. My lords and my lady take charge.
There is no... I'm responding to what has happened. Let us be fair to each other. And my lord, what I'm saying is this, that for purposes of those applications, the application under Article 165, because in the morning when we raised the issue orally, the questions that was raised, you are raising issues against the Deputy Chief Justice, who is not a party. She is a party now, and we have served her. We too there, application on the issues of the constitutional violations regarding the empanelment of this bench. We shall need the court's directions on that issue. And we've gone through the authorities within the short period that we were here. So we are standing on solid grounds. We just need sufficient time to do our business. Issue number 2, my lord, if that applications were to succeed, then it would effectively remain, as my learned colleague Mr. Ngoya had indicated, that then the issue of recusal of your lordships becomes academic. But if your lordships were to hold that all these serious injustices that the petitioners allege were committed by the Deputy Chief Justice are okay, then we shall now address you, the issues that concerns you. And I need to add, on the issues of authorities, because now we've been told different instructions. When we came here, we thought that while we were proceeding and taking directions, prepare the team in the office, let them prepare authorities to argue on the issue of recusal. When we were given 1 hour, we told them, oh, stop on the issues of recusal, now we are dealing with another thing. So, my lord, we cannot be able to argue, if it is today, we cannot be able to argue as expected by our client on the question of recusal. And there is no similarity of issues. Therefore, my lord, I urge you that let us adopt fair procedure. This fair procedure has always been there.
Specific application for recusal.
There are 2 applications.
Where are they?
We are not.
At least I know. Therefore, you mentioned one.
We are not.
We are actually bringing them even. One of them in number 050 is an application dated, I believe, yesterday, 21st of October. There is another one.
Okay, these are the directions we are making. We'll deal with the application before us. The application for empanelment of this bench. Where's the application? Where's the application? Empanelment.
Yes.
Perhaps before you give the directions, with my learned friend is Kimoto. She's informing me that she was not aware of directions given that applications be filed and they come back before you. And now her petition has been integrated in the consolidated petition. That is petition number E013. Therefore, she's not been able to file an application either for recusal or for challenging the empanelment. She was just requesting if she can be served with those applications and the responses, and she be given time, 1 hour just like the others, to file her similar application if she so wishes. Because now she's participating in a proceeding, she did not directions.
Counsel. So listen to this and listen to this very carefully. All of us acknowledge the momentous import of the proceedings before us. And all of us are enjoined by the rules of natural justice to do what is right. This bench is not going to be taken round in circles. We will not be taken round in circles. We are here to do justice for the petitioners, justice for the respondents. And anything which is intended to delay these proceedings will not be acceptable because both parties have come to this court under certificate of urgency. Let us be very careful how we argue our matters. We want everybody before us to get justice. That justice will not be possible if every advocate who stands up wants to take the cause in circle. We will not allow that. I'm making final directions on this matter. The matter which we are dealing with is an application dated 22nd of October 2024 by Jindo Matiba and Company Advocates. It seeks orders under Rule 3 of the Constitution, we are dealing with the issue of empanelment. And then after that, we'll make a ruling for the way forward. So let us proceed. Let us be courteous to each other. Let us be courteous to the parties before us. Parties before us are very okay, but let's not be a theater by advocates to derail the process. I beg you. On the issue of time allocation, please, you are not audible.
Oh, I'm sorry, I'll speak loud. I received instructions yesterday from the Syria that I come and make an application that Syria would like to be enjoined to this matter. We all know Syria. We can't pretend that we don't know. And we know the role Syria has played in advancing jurisprudence, constitutionality, and the rule of law in this country. So I urge you respectfully that you place my name on record. Secondly, I would like also to place my name on record in my own right as an elder at the bar and one who has seen for a number of things which I may not be able to say if I'm representing the Syria.
That is okay. We have done that.
Thank you very much. May I then comment on one small thing,
Yes, sir.
My lords, the country is in a crisis. There is a constitutional crisis. There is a national crisis. And our coming to this court is like commencing or opening an opportunity for healing in the country. And if I may say so with tremendous respect, this is not a matter where you should be allocating some 5 minutes, 10 minutes, 20 minutes. No, that is not suitable. Let these lawyers talk. They are part of the healing process to the 15 million of Kenyans. A number of them are glued now to radios and TVs, trying to hear what is being said in this court. And for this honorable court to come and say that my ever friend, Mr. Mute, will only have 10 minutes, will have no 5 minutes.
Mr. Mute asked for 10 minutes and we allowed him to have 10 minutes.